We'll now turn to Professor Samuel Brunson, who is Associate Dean for Faculty Research and Development and the Georgia Reinthal Professor of Law at the Loyola University Chicago of Law. Professor Brunson.
Thank you, Whitney, and Christine, Rachel, and everyone else at the Canopy Forum for having me here. So when I put this together, I actually emailed them my piece and I said, I've got a title and I don't really like it. And sitting here listening, I think I've come up with a title that works for me, which is The More Things Change. Because while Smith, as others have discussed, represented a break with prior First Amendment law in some ways, it was actually a continuation in others. And to get that continuation, I'm going to jump back all the way to the 1600s, to the formation, the founding of the Society of Friends, often known as the Quakers. And early on in their existence, the Quakers adopted a policy called the Peace Testimony. The Peace Testimony is a religious policy against outward wars and strife and fightings with outward weapons. In essence, it forbids Quakers from fighting in war on penalty of being disowned from their meeting. But it turns out that the Peace Testimony isn't limited to actual physical fighting. A Quaker can also violate the Peace Testimony, for example, by paying for war. And in fact, this was a real problem. During the American Revolution, many Quakers refused to pay the war taxes. Their refusal often led to their imprisonment and to the government confiscating and selling their property to pay the taxes that they hadn't paid. Now, over time, the relative importance of the Peace Testimony for Quakers waxed and waned. It kind of seems to have hit a low point between, say, the Civil War, where many Quaker abolitionists actually agreed to fight in the war, and World War I, where most Quakers of the right age agreed to fight and didn't object. But after World War I, it started becoming important again. And the Quakers worked with the government to help create procedures for conscientious objectors. This is all fine and good, but my area of law is tax. And now we get into what I like, which is this. They didn't get any procedures put into place for conscientious tax objectors. Now, initially, this wasn't a significant problem. Up until about the 1940s, so for the first 3 decades or so of the federal income tax, the federal income tax was largely a tax on the wealthy. In 1939, only about 5% of Americans paid income tax. But it turns out World War II was very expensive. And the federal income tax shifted from what's colloquially known as a class tax into a mass tax. Where in 1939, only about 5% of Americans paid the federal income tax, by the end of the war, 1945 or so, that had jumped to 60%. With that, suddenly financially supporting war was a real potential problem for Quakers who subscribed to the Peace Testimony. So what did Quakers do? They took a couple different approaches. Many Quakers involved figuring out what percentage of the federal budget paid for war. Say it's 40%. They would pay 60% of their taxes and they would decline to pay the other 40%. What they did with that 40% depended. Some of them probably took nice vacations. Some of them donated that amount to charitable organizations. Others put it into an escrow account and said, we will release this to the government once the government agrees not to spend our particular money on war. Other Quakers took a different approach. They figured money's fungible, and because money's fungible, that is, it can be used however you want. Any funding to the government potentially funded war, and they refused to pay taxes on that theory. It's also worth noting, even though I'm talking primarily about Quakers, conscientious tax objection isn't limited to Quakers. They just make for a good through line, a good story. There were non-Quaker religious pacifists. Amish object to Social Security, paying Social Security taxes and receiving Social Security. Some Catholics objected to paying taxes because they believed that the government funded abortion. But again, for RFRA purposes, the Quaker Peace Testimony is the most important and salient of these tax protests. So the IRS did not accept religious justifications for not paying some or all of Quakers' taxes. So it would garnish their wages, and it sued, among other things, to collect unpaid taxes and interest on the unpaid taxes, and sometimes even penalties. And Quakers almost immediately began claiming that the Free Exercise Clause of the First Amendment required the government to accommodate their beliefs and allow them to not pay taxes. Now, quick spoiler alert, that never once worked in any court anywhere. The courts uniformly disagreed. They also uniformly accepted the Quaker tax protesters' sincerity as a given. So the first case that I found to lead to a published opinion was in the tax court in 1961. And the judge there determined that the tax law didn't violate the Quaker's First Amendment rights because it did not directly restrict his religious practice. Over the course of time, over the next decade or two, courts refined this analysis. By the end of the 1970s, courts justified the collection of taxes in violation of the peace testimony on the grounds that the tax law was levied uniformly on people of all beliefs and of no belief. Thus, however the government chose to use the money it raised, its collection didn't unreasonably burden Quaker taxpayers' free exercise rights. So right here is why I'm thinking of calling this the more things change, because even pre-Smith, this standard that the law was levied uniformly on people of all beliefs and no belief looks a whole lot like the standard that the Supreme Court adopted in Employment Division v. Smith. And I'm not going to go back into that because we've discussed it, but just really briefly, laws are constitutional if they're generally applicable and facially neutral. It's also worth noting that while Smith doesn't actually refer to any of the Quaker cases, it uses tax as a major illustration of the jurisprudential test it's adopting. The court says that if prohibiting the exercise of religion is not the object of the tax, but merely the incidental effect of a generally applicable and otherwise valid provision, the First Amendment has not been offended. As we've heard, Congress didn't like the Smith decision and passed RFRA to reverse it and revert the law of free exercise to its pre-Smith state, which, as we've seen for religious tax protesters, is exactly the same as post-Smith. But some Quaker pacifists decided to see if RFRA would make a difference. In spite of about 3 decades of precedent going against their position, they continued to refuse to pay some or all of their taxes. Rosa Packard, the first protester to have a case decided post-RFRA, made both First Amendment and RFRA arguments for why she shouldn't have to pay taxes. The court dismissed her First Amendment argument summarily, but it recognized that she raised a new argument. She said even if she owed taxes, RFRA protected her from penalties. And the penalties can be substantial. They can be 20 to 40% of the amount of the tax. So if she didn't pay $10,000, the penalties could be another $2,000 to $4,000 on top of that. She couldn't argue, I guess she could have argued, but legally she couldn't argue that the government lacked a compelling purpose in collecting taxes. That's been very clear through case law. But she argued that penalties were not the least restrictive means of collecting taxes. After all, she said, hey, I haven't paid taxes in 20 years in spite of penalties that accrue. The least restrictive means of collecting tax is levying on tax protesters' bank accounts. But the court didn't buy it. They said, first of all, not all delinquent taxpayers have bank accounts that can be levied upon. In addition, if the IRS just levied on bank accounts, there's no stick to encourage tax protesters to pay their taxes. Rather, they can just wait there, play what we call the audit lottery. And if they get audited, then the money gets collected. If not, it doesn't. So the court said no RFRA right. RFRA doesn't give you the right to even get out of tax penalties. And a couple years later, 2 courts of appeals affirmed the idea that RFRA did not excuse religious tax protesters either from paying the underlying tax debt or from paying penalties. Now, on top of that, in 2005, the IRS officially designated this argument that I have a religious right not to pay taxes as a frivolous argument. And what does that mean? It basically means that on top of taxes, interest, and the 20 to 40% penalties that we've talked about, if you raise a frivolous argument in a judicial proceeding, it can result in a fine of $25,000 on top of everything else. Now, all of this is to say, Quakers don't get to not pay their taxes based on sincere religious beliefs, either under the First Amendment or under RFRA. So where does this leave them? Because some Quakers and other religious individuals have legitimate, sincere religious objections to government spending. Well, basically, they're not protected by the Constitution. They're not protected by any existing statute. If they want the ability to keep their tax dollars from supporting war, they need legislation. This is something that worked for the Amish. Self-employed Amish individuals, by statute, don't have to pay the self-employment tax. And since the 1970s, what is currently called the Peace Tax Fund Bill has been introduced in Congress a number of times, every time unsuccessfully. It's never passed. Recently, it was sponsored by Representative John Lewis, and when he passed away, Representative Jim McGovern took over the sponsorship. Importantly, though, because neither the First Amendment nor RFRA allow a taxpayer to refuse to pay taxes, things are the same today as they were 30 years ago, as they were 50 years ago. Thank you.